Unpack this with Hugo Pienaar, Director of Employment Law Practice at Cliff Decker Hofmeyr. Hugo, thanks for your time. We appreciate it. So this case, many would argue, sets a precedent when it comes to refusing a vaccine without having the proper grounds to do so.
Absolutely so. And what is, of course, new about this matter in all previous reported cases where employees were dismissed for failing or refusing to take the vaccine, they were dismissed on the basis of their incapacity. And in this case, the employer elected to follow a different process, i.e. one of an operational requirement, i.e. a typical retrenchment scenario, and used that as a basis to terminate the employment of the employee. And as you correctly put forward, is that she basically relied on 3 grounds, and those 3 grounds were not accepted in this particular case.
Yeah. Also, the fact that this employee was retrenched without a severance package, that sounds very untoward in terms of the way forward, because normally when someone's retrenched, they do get their severance package. So why in this case did the company get allowed to actually take this route of retrenchment instead of dismissal?
Yes. Well, what the company did consider, and of course in law, when you retrench, you're entitled to 3 basic payments: the notice pay, the outstanding leave, and then the severance pay. Now, severance pay in terms of Section 41 of the Basic Conditions of Employment Act simply says that you're entitled to 1 week's remuneration for every completed years of service. But of course, if you unreasonably refuse an alternative position or an offer, even with a different employer, you will forfeit your severance pay. And what the employer did in this particular matter, it considered the 3 objections of the employee. It said, well, the first one is about personal reasons, and she said she didn't know what the ingredients were. She raised the issue of religion and relied on the statement of our previous Chief Justice and said it's something to do with the New World Order. She tried to submit medical reasons, but it was not substantiated. And the employer said, well, there's an alternative for you, be vaccinated. The employer then argued that this is a reasonable alternative to your termination. The employer refused that, and hence the employee correctly forfeited a right to severance pay.
In an instance like this, what happens if an employee eventually decides to get vaccinated? Can they then ask the company not to retrench or fire them?
Yes, absolutely. So the employee would comply with the alternative and say, well, I'm now vaccinated, there's no reason to terminate my employment. But of course, Shahan, what is also interesting is that we've so far seen cases mostly based, one on incapacity, or this case, operational requirements, but we've not seen a case where a reported case where an employer decided, I'm going to terminate based on your refusal to obey a reasonable instruction, i.e. I have a vaccination policy in place and you simply refuse to be vaccinated. That's a reasonable instruction, and I'm going to terminate on that ground. There's, of course, not yet a case decided on that score.
And for the benefit of those who have these questions tonight, remind us about their rights when it comes to how these vaccine mandates work in companies. On what grounds can you actually refuse to take a vaccine? A legitimate ground, I'm saying.
Yeah. Yes. Well, of course, when the principle was introduced that you could have compulsory vaccination, you had to do a proper risk assessment in order to ensure that the employees you require to be present is operationally justifiable. So they must be present. You've done a proper risk assessment, you've consulted with the relevant parties, and importantly, in terms of your policy, you provided for objections. In other words, employees may be object on medical reasons or typical conscientious reasons, i.e. your constitutional grounds. Now, of course, they're entitled to do that and they will be consulted. But of course, as we know, no right is absolute. And of course, there's also the employer's right. And what happens in most of these cases is that we look at the collective right as opposed to the individual right. And in this particular cases, the collective right would override that of the individual.
Thank you so much for your insight.
So they can raise those objections.
Okay, thank you so much for your insight. Appreciate it. Hugo Pienaar, Director of Employment Law Practice at Cliff Decker Hofmeyr.